falsifying business records, issuing false financial statements, insurance fraud, permanently bar Mr. Trump, Donald Trump Jr., Ivanka Trump, Eric Trump, from serving as an officer or director in any corporation or similar entity registered and or licensed in New York. Each statement was personally certified as accurate by Mr. Trump or by one of his trustees as part of the loan process. Good morning. Following a comprehensive 3-year investigation by my office, including witnesses, interviews with more than 65 witnesses, and review of millions of documents that were submitted by Mr. Trump and others, I am announcing that today we are filing a lawsuit against Donald Trump for violating the law as part of his efforts to generate profits for himself, his family, and his company. The complaint demonstrates that Donald Trump falsely inflated his net worth by billions of dollars to unjustly enrich himself and to cheat the system, thereby cheating all of us. He did this with the help of the other defendants, his children, Donald Trump Jr., Ivanka Trump, and Eric Trump, and former Trump Organization CFO Alan Weisselberg and Trump Organization Controller Jeffrey McConney. Mr. Trump and the Trump Organization repeatedly and persistently manipulated the value of assets to induce banks to lend money to the Trump Organization on more favorable terms than would otherwise have been available to the company. We show that they violated several state criminal laws, including falsifying business records, issuing false financial statements, insurance fraud, and engaging in a conspiracy to commit each of these state law violations. We believe the conduct alleged in this action also violates federal criminal law, including issuing false statements to financial institutions and bank fraud. And we are referring those criminal violations that we've uncovered to the United States Attorney for the Southern District of New York and the Internal Revenue Service. As a result of these violations, we are asking the court to, among other things, permanently bar Mr. Trump, Donald Trump Jr., Ivanka Trump, Eric Trump, from serving as an officer or director in any corporation or similar entity registered and or licensed in New York. To bar Mr. Trump and the Trump Organization from entering into any New York State commercial real estate acquisition or from applying for loans from any financial institution in New York for 5 years. To pay for the financial benefits obtained as a result of the persistent fraudulent practices at an estimated $250 million. At the center of the year-long financial scheme were the statements of financial condition that were prepared annually by and for Mr. Trump, specifically from 2011 to 2021. These statements were compiled by the Trump Organization executives and were issued as a compilation report by Mr. Trump's accounting firm. The statements are explicit that the preparation was the responsibility of Mr. Trump. We're starting in 2016, the trustees of his trust, Donald Trump Jr. and Alan Weisselberg, for the sole benefit of Mr. Donald Trump. Each statement was personally certified as accurate by Mr. Trump or by one of his trustees as part of the loan process, that using the false square footage improperly inflated the value of the apartment almost threefold. Mr. Weisselberg admitted that this amounted to a overstatement of, give or take, $200 million. Misrepresenting the size of the apartment was only one of the many ways that Mr. Trump intentionally misvalued his asset for the purposes of increasing his net worth and inducing banks to offer more favorable terms. Mr. Trump also routinely ignored legal restrictions on development rights and marketability on properties that would significantly decrease property values. For example, let's take Trump Park Avenue in New York. This building contains both commercial and residential space. The unsold residential condo units owned by Mr. Trump and the Trump Organization represented the lion's share of the reported value for this property. Mr. Trump and his children intentionally ignored legal restrictions on some of the units that would have drastically changed the valuation. Specifically, the 12 of those units were actually rent-stabilized apartments. A professional appraiser valued those 12 units at around $750,000, noting that the rent-stabilized units cannot be marketed as individual units for sale because the current tenants cannot be forced to leave. Despite this professional valuation, and Mr. Trump knowing full well the legal restrictions the 12 rent-stabilized units were valued, he valued them collectively on his statements at $49 million. That is about 65 times the appraised valuation. Mr. Trump also blatantly ignored legal restrictions at Mar-A-Lago. Mar-a-Lago was valued on the false premise that it sat on unrestricted property and could be developed for residential use. However, Mr. Trump knew that Mar-a-Lago was subject to a host of onerous restrictions and limitations. Mr. Trump himself signed deeds sharply restricting changes to the property and donating his residential development rights in an effort to get a tax deduction and later to lower his property taxes on the property. The deeds also require Mr. Trump to donate over 23% of Mar-a-Lago's value to the Historic Trust for Historic Preservation if he ever sold it. Despite these significant restrictions, Mr. Trump valued the property based on the false premise that it was an unrestricted residential 18-acre plot of land that could be sold and used as a private home. In fact, the valuations represent that these restrictions don't even exist. The club generated annual revenues of less than $25 million and should have been valued at about $75 million. However, Mar-a-Lago was valued as high as $739 million. Mr. Trump used inappropriate schemes to inflate the value of his other golf clubs. He valued the clubs based on their fixed assets. In other words, the money spent to acquire and to maintain them, despite being informed by valuation professionals that this practice was inappropriate for a club operating as an ongoing business. He again added a brand premium when determining the value of the club, but claimed in his statements that he did not. And he inflated the value of unsold memberships, often by hundreds of thousands of dollars per membership, even in situations where the memberships were given away for free at Mr. Trump's direction. Inflating his reported net worth was just the first part of the scheme. He then used these false statements of financial condition for his own personal gain. Mr. Trump and the Trump Organization have obtained hundreds of millions of dollars in real estate loans and insurance coverage using these statements.